Excellent. Welcome to the final panel of the symposium, The Great Balancing Act, Evolving Issues in Multiple Use Management. So I'm Alison Flint. I'm Senior Legal Director at the Wilderness Society, moderating today's panel. And our panelists are going to introduce themselves in a moment, but I'm going to try to briefly frame up how we're going to spend this last 75 minutes. We have been assigned the perhaps impossible task of addressing the endless array of evolving issues in multiple use management at the very tail end of the conference, and then trying to tie that to the theme of the conference. So we're going to do our best. It has now been nearly 50 years since Congress enacted the foundational laws like the Federal Land Policy and Management Act and the National Forest Management Act that intentionally, I think, paired a policy of public land retention, which we've been talking about for the last 2 days now, with a mandate to manage most of those federal public lands for multiple use and sustained yield. It's been nearly 20 years since the U.S. Supreme Court described multiple use as a deceptively simple term for the enormously complicated task of achieving a balance among the many competing uses to which land can be put. That task has become even more complicated in the last 20 years with climate change, loss of biodiversity, recreation demands, long overdue calls by tribal nations to co-steward and co-manage their ancestral lands and resources, and the need for sustainable development and conservation of both renewable and non-renewable resources. So we've had much ricocheting over the past 5 presidential administrations, and now we find ourselves in the midst of what feels like the most heated debates yet about how to interpret and apply multiple use. Those policy debates are playing out across all 3 branches of federal government, and as we've been talking about in the context of an unprecedented effort to both deregulate and also dismantle and disempower the federal land management agencies. The intended result, from my perspective, at least, appears to be to decisively and permanently tip the multiple use scales in favor of extraction and consumptive uses, and ultimately privatization, getting to the theme of our conference. Of course, with implications on fossil fuel development, hard rock mining, grazing, conservation and ecosystem resilience, recreation, timber production, wildlife habitat, climate change, and the rights of tribal nations, all of those different interests in multiple uses. So we're going to try to hit on many of those through a moderated discussion format that looks a little different from the other panels we've done, acknowledging that we could easily have an entire panel on any of the one topics we'll try to cover. So you're going to get, some vignettes and some snippets rather than a complete picture of each of these kind of hot topics in multiple use management. And we'll aim to reserve the last 15 minutes or so for audience Q&A, but because of the moderated discussion format, please put your questions into Slido as we go, and if they make sense within the format, I'm gonna try to feed them in to the planned discussion. All right, so with that, multiple use is informed not just by the 3 branches of federal government, but by those branches of government responding to a range of constituents and rights holders representing different interests. So let's start by having each of our panelists briefly introduce themselves and then describe what interests or perspectives you're bringing to the table and how you see your role in informing today's debates about multiple use of our shared public lands. So Natalie, please go.
Hi there, I'm Natalie Landreth. I'm a citizen of Chickasaw Nation of Oklahoma. In the previous administration, I was Deputy Solicitor for Lands. Before that, I had the good fortune to work for Mr. John Echohawk for 21 years, the Native American Rights Fund. And my perspective is really working from the idea that when, as you referenced earlier, when you're rebuilding land management, that tribes should be included at the very basis and throughout all aspects of federal land management. They are governments. They are not stakeholders, they are not interest groups, they're the original title holders of 100% of the land in the United States. And because of that legacy of their status, they actually have rights that nobody else has that will be very useful during this particular time. So I'll mention very, very briefly only, I'm gonna mention the 3 that they have that nobody else can use and 1 that only governments can use, and 1, government to government consultation. in EOs, regs, policies. This is not a public meeting. They have a right to have government-to-government meetings. They are not bound by traditional public comment periods. They have those rights simply because they are governments. Second, co-stewardship and co-management, which I know was discussed a little bit yesterday in the Land Back panel. This also has its origin. It's not based on a single law. It's based on the body of law, again, from the fact that there are governments who are eligible to manage land. And it's important to understand that the pieces of co-stewardship and co-management put in the last administration are still there. The IMs, departmental manuals that provide for these processes, because in my view, they're bipartisan. The third aspect, and by the way, NGOs, can't co-steward or co-manage lands. Nobody gets consultation rights. These are unique roles for tribes that they should be maximizing right now. And the third, I'll just say briefly, although you can teach a semester-long class on it, is 638 contracting, which is law 638 is the number of the law, Public Law 638, allows tribes to take over programs and services and the federal funding that goes along with it. So that can be used to manage lands, administer monuments, and frankly, there are monuments in the United States right now that are administered this way. So that's the perspective I'm working on. The last piece that only tribes can do along with other governments is cooperating agency status. So that's the perspective I bring to a lot of the land management, is not only right now are these perspectives useful, but they need to be incorporated from the ground up throughout the agency when we resume what I call normal operations.
Excellent. Thanks. Louis.
Thank you. I'm Louis Geltman. I'm the VP for Policy and Government Relations at Outdoor Alliance. We're a coalition of the national advocacy organizations for climbers, kayakers, mountain bikers, backcountry skiers, surfers. Outdoor recreation is the most common way that Americans come to know their public lands, and outdoor recreation supports nearly $1.2 trillion in gross economic output, 2.3% of GDP, and nearly 5 million jobs. We're super grateful for our partnership with the outdoor industry, particularly Conservation Alliance and Outdoor Industry Association, who are great partners for the outdoor recreation community in this work. In terms of how we engage in advocacy, I think we're really focused on helping people kind of translate their love of place, their experiences in the outdoors into advocacy. And I think our hope is that when people are really speaking from that direct personal experience, that is a very nonpartisan message. And our hope is that we can use that to move the needle in favor of conservation and sound management from a recreation access perspective.
Thanks. Katie.
Hi there, everyone. My name is Katie Schroder. I'm a partner at Davis Graham in Denver, a law firm. We've been around for 100-some years. My particular before I was with Davis Graham, I should mention many years ago, about 20 years ago, I started off in the solicitor's office as part of their honors program. So I'm very familiar with the Department of the Interior and the BLM, and I have carried that expertise, if you would, I don't know if 20 years ago if I would call it expertise, but at least that knowledge into private practice, where I represent clients doing business on the public lands. Most of these clients are energy clients. My real probably focus, if not bread and butter, are oil and gas clients. But I'm pretty industry agnostic, wind, geothermal, carbon capture. But typically, the common theme is companies or people with economic interests in the public lands. In terms of my personal view, that's always a little bit awkward when you're in private practice, right? Because you're hired to advocate for someone else and someone else's interests. So it's not the same as being, in an organization or certainly kind of following a passion work. But I would say that, and so I say that because at times you may hear me say today, well, my clients would take this perspective or my clients would take that perspective, not because I agree or disagree with them, but that's just the position that they've been advocating for. I think if I had to draw a kind of a common theme amongst the different clients and economic interests, I think it would be one of, protecting existing rights that they have on the public lands, and also just maintaining regulatory certainty, knowing what the rules of the game are, so that they can efficiently do business.
Thanks, Mark.
Thanks, Alison. Good to be here with all of you. I know most of you, I suspect, in the audience, but for those of you who I don't know, I'm Mark Squillace, and I teach in the Natural Resources Law program here. I'm really happy to be participating on this panel, even given our limited time. I'm just going to sort of share with you a little bit about some of the things that I do that are maybe a little bit outside my role as a law professor. And those are things like writing public comments on various proposals that government agencies do. I think it's really important right now for law professors and students in particular to get engaged in this. I mean, we are seeing right now, in many cases, the government's not giving us the opportunity to comment even on these things. That raises really serious questions about the scope of the administrative record, whether it's going to be complete or not, because if there's no comment and then response to those comments, that raises, I think, a really important question under the Administrative Procedure Act. I think we can also participate as amici curiae in lots of cases. I'm actually working on a brief right now with some students on the Gross Reservoir expansion, kind of an interesting project we're on. I think we as academics can also be engaged in media and starting to sort of bring issues to the fore and to the public on important questions that are arising in this area. And then finally, I would say that the academic community really ought to be thinking through some of what we've been talking about here in the past couple of days, which is, what does the government look like in the next administration? How should things evolve? We've talked about the fact that we can't go back to where we were. So what are we thinking about in terms of how we go back to a different paradigm than what we have now? And I'm hoping that all of us, academics or not, students or not, can be thinking about the next iteration, I guess, of the government. Thanks.
Great, thank you all. All right, let's pivot to some of the major multiple use policy debates of the day. We could do an entire panel on any one of these and probably more. So these are going to be some snippets and some thoughts and a little bit of a introduction to them if you're not tracking. So Katie, why don't you start by telling us about oil and gas leasing reforms?
Well, hi there, everyone. So I think there's two things I'd want to touch on and about where the world of oil and gas is at the moment. And really, I think the biggest changes we're seeing is not administrative changes, but congressional changes that came out of the Reconciliation Act, or the One Big Beautiful Bill Act, whatever you want to call it. But there were really, I think, significant changes to oil and gas leasing and on the public lands that are probably the most significant since the 1987 Reform Act. Even before, I believe, the 87 Reform Act, I believe, there was a provision of the Mineral Leasing Act that said that the Secretary may lease lands for oil and gas development. And so even if land use plans, for example, identified lands as open and available for lease, the Secretary always had the discretion not to lease. And the One Big Beautiful Bill Act, or the Reconciliation Act, or I think someone else called it something else, Resolution 1. Anyway, there's a lot of names floating around, depending on your leaning, I guess. But in the Reconciliation Act, Congress eliminated the provision that said the Secretary may lease and changed it to change that language to say the Secretary shall lease lands that are nominated by industry or BLM. But industry or the outside, the public always had the right to tell BLM and the Secretary, hey, I'm interested in this piece of land, you should lease it for oil and gas development. That's always been the case, or maybe not since the beginning of time, but for a long time. And so now the statute directs the Secretary to lease if they're responding to what it's called an expression of interest or nomination. and those lands are identified as open for leasing in the resource management plan at the time that the nomination was submitted. And that's kind of a little, there's no funny business there, I think, is what Congress was trying to say. Well, you can't amend your resource management plan to make it unavailable for leasing later on. The other significant point or element is that the Reconciliation Act directs the Secretary to lease with only the stipulations that are provided for in the resource management plan. The Secretary always had the discretion, well, not always, but had some discretion to add additional stipulations to leases when they were issued. And those stipulations have different restrictions on how operations can occur on the lease in response to site-specific conditions. And Congress said, no, you can't do that. What we want to see is the provisions that are, the stipulations that are provided for under the RMP. And so I think if you were to think about, okay, well, what does this mean for public lands management? I think one point is that based on this regulatory change, or excuse me, statutory change, resource management plans are going to become even more important, right? Because now they really do say, this is what BLM and the Secretary can do with respect to oil and gas leasing here and not here. Whereas before they were more of a general, resource management plans were more of a general guide, I would say. Certainly depending on the administration, like they were viewed as more of a general guide or a baseline level of protections where then, the Secretary had discretion not to lease in certain areas or to add additional stipulations to leases. So I think that is, in my opinion, a pretty monumental change in how business is done on the oil and gas side. I think this was done in reaction to the leasing moratorium we saw at the beginning of the Biden administration, and also some administrative efforts under the Obama administration to slow oil and gas leasing. The other thing I just want to mention briefly is that and this is particular to the Department of the Interior, is that we're in an energy emergency. Can't we all tell, right? The lights are flickering, but we're in an energy emergency, and the Department of the Interior released certain emergency procedures that allow for expedited NEPA review, Endangered Species Act review, and National Historic Preservation Act review for energy projects. And it's been interesting because I haven't seen many people take advantage of this. I don't have any firsthand knowledge of anybody who's taken advantage, any company that's taken advantage of these procedures. But I've seen the headlines of, there are some circumstances where people have used them. What I think is interesting is I think with some of the administrative and legislative changes that have happened with NEPA, as well as the 7-county decision, I'm going to assume folks are aware of that, that I think there's been enough potential for NEPA streamlining that I think I would say, well, is it worth taking this really aggressive emergency procedures to expedite your NEPA review when there's more streamline and probably more certainty around those streamlined procedures available through, the more established channels. So that's sort of the front as I see it on the oil and gas side.
Katie, one question from the audience that I'm going to feed in now. One of the other things that the One Big Beautiful Bill Act did was reduce royalty rates for oil and gas. And so how are your clients thinking about the now more advantageous back to lower royalty rates on public lands versus how they might choose to develop on private lands or state lands?
So that's an interesting question. Just to clarify that the lower royalty rate only applies to new oil and gas leases. As a practical matter, because of the Inflation Reduction Act was passed in 2022 that increased the royalty rate by about 4 percentage points, there were not that many leases issued in that time frame, in the window between 2022 and when this One Big Beautiful Bill Act royalty rate reduction took effect. And so the One Big Beautiful Bill Act restored royalties to the prior pre-IRA levels. So I don't know how impactful it is because you simply don't have that many oil and gas leases out there with the higher royalty rate.
Okay, and for the folks in the audience excited to talk more about planning, I see your questions. I promise we're getting there. But first, Natalie, can you jump into the BLM public lands rule?
Oh, yes, such a delightful topic, especially right now. Public comments close November 10th, just FYI, if you're interested in this at all. The public lands rule, first thing, I want to say what it isn't, because the top line talking point that you probably heard on a lot of the media was totally false, that it elevated, I have to use air quotes at least once, elevated. Conservation as a use is totally untrue. It's in the statute. It's also in a bunch of common law. For people that bothered to read the preamble, those cases are actually cited in the common law saying the regulation is not creating this. It already exists. So, and it filled a lot of other aspects, a 50-year regulatory gap of acknowledging that, as well as other, things on the wish list of the BLM, including ACECs and more specific procedures for nominations. There was a lot in it, career developed, a lot in it. But what I want to talk about it also was and is a model for how some of these regulations should be put together moving forward. It references tribes almost 50 times. One of its only 10 goals is the increase of co-stewardship, which I might point out, as Professor Sozi mentioned yesterday, is part of the current strategic plan of the Department of Interior to increase tribal co-stewardship and co-management of federal lands. That's in there. That's goal number 10 listed in that particular rule. And then there are 5 different places where it specifically includes tribes in a way so that they're not after the fact asking for consultation or trying to peek in under the curtain after decisions have already been made. Well, there's 4. The first one was co-stewardship as an explicit objective. First is it makes consultation enforceable. It's the first environmental regulation that did that, the only other regulation that makes it legally enforceable. There are cases on it. You can bring cases under the EO with varying results. But a regulatory mandate to engage in government-to-government consultation exists under the National Historic Preservation Act. And that's where most of us encounter it. This replicated that for the public lands. That was an incredibly valuable get for tribes because as a lot of times, including now, you'll see it being skipped or treated like a regular meeting. So, and it becomes something more than just policy guidance. The other way, it was the first ever regulatory definition of indigenous knowledge in any DOI regulation. Now, it did not invent that as the Department of Interior. It used the one that had been derived through public comment and public meetings that was set forth by Council on Environmental Quality, or CEQ. In its very lengthy 50-page, maybe 55-page memorandum on the use of indigenous knowledge in the agency, it put that definition in there, and it established indigenous knowledge as high-quality information equivalent to other science. Very important when you're going through NEPA processes. And it directs BLM to use indigenous knowledge in developing alternatives. And so that had also never been seen before. The last thing it did was on, cooperating agency status. Well, there's 2 more, second to last, is cooperating agency status. Tribes, they were directed to be included as cooperating agencies when they requested it, because one of the things that came out in public comment was often when they request it now, and I could, name examples where this is occurring, it's completely ignored. And they'll say, we have specific expertise about this landscape, about the water table, about managing this particular wildlife. We do this all the time. We uniquely interact with this landscape. And so they would say, we would like cooperating agency status. In some places it was granted. The refuge, Anwar is one example where, tribes had cooperating agency status. But, across the country, it's often ignored, according to tribes. And so this took that away and basically said, if they want to be cooperating agencies, they get to be cooperating agencies. And this is, as I mentioned in my opening part, one of the ways that I think going forward when people have to rebuild is to think of examples like this. The last is ACECs. So there had been basically a systemic rejection of ACEC nominations, areas of critical environmental concern, for the handful of you that maybe aren't familiar with that, by the agency. And this created not only, other aspects of the BLM wish list, including more specific processes and procedures for establishment of ACECs, but it basically said it created a process for tribal nominations of culturally significant areas as ACECs, so they could then be addressed in land management planning. And it also directed that the manual on ACECs be updated to include this. So these are things that did not exist in regulation before, and a lot of them were put into the public lands rule with the idea of tribes being partners, being on the landscape as land managers. So I think that's one of the things going forward that really has to happen. They're part of the multiple use sustained yield mandate. And yes, I said at the beginning, I'll say it at the end, conservation is a use. It's not a non-use, it's a use. So I will pause there.
All right, Mark, what do we need to know about hard rock mining and critical
my
minerals
goodness,
over the last 150 years?
We need a couple hours on this topic, and I'm going to start with an anecdote instead of addressing that directly. When I was a third-year law student, I had the opportunity to testify before the House Natural Resources Committee, which held a hearing in Grand Junction, Utah. Mo Udall was the chair of the committee, and I was testifying in favor of mining law reform, which was the subject of that hearing at that time. And it's been many decades since I did that, and it is shocking to me that here we are in 2025 and we still do not have mining law reform. It is just incredible that we've not managed to get past this. And the reason this is relevant, of course, to the multiple use issue is because mining is the one subject, hard rock mining is not subject to general multiple use kinds of criteria. You have a right to locate a mining claim on public lands, and you have a right to develop that claim irrespective of other uses that might be made of that land. The location system, we talk about it. It's frustrating to those of us who have worked on this issue for many years. John Leshy, of course, wrote the main book on the subject, and I know many of us would like to see some movement on this issue. Let me just add one other point. I know we're short on time, but I thought I would raise an issue that I think is really important when we're thinking about multiple use of public lands. And that is the way that mining companies are allowed not just to locate mining claims, but also to dump their waste rock on our public lands. There's this obvious example that some of you are probably familiar with the Rosemont mine down in Arizona. Rosemont is proposing to use 4 square miles of national forest land to dump their waste rock. And that will continue to be national forest land once they're done, totally unusable, to my perspective, for any kind of multiple use at that point. And we need to rethink how we're doing this. Obviously, there's been a lot of litigation on these issues, somewhat successful, but still mining companies are able to circumvent some of the rules that apply in this area to dump their rock on our lands. And we ought to be able to figure out a way to exchange lands in a more efficient way than our current exchange rules allow, so that we're not using our public lands for those purposes, or even sell the lands. I'd rather that the government didn't end up owning lands that are totally unuseful for any kind of multiple use purpose. We ought to get some money for it at least. And of course, they're using these lands without having to pay for the privilege of doing it. So if there's one issue that beyond reforming the entire hard rock mining law, I'd love to see some focus on reforming this ability to use our public lands for their waste rock. Thanks.
Thanks. All right. Well, we've spent most of the last 2 days talking about interior issues, but we don't want to totally neglect the Forest Service. That's been sprinkled in here and there. So Louis is going to bring us up to date on the big Forest Service policy debate going on right now.
Thanks. So I guess I just want to talk quickly about the Forest Service roadless rule, which is subject to this rescission effort at the Forest Service right now. A quick history. The roadless rule was promulgated in 2001 at the end of the Clinton administration, and fundamentally it does 2 things. It prevents commercial timber harvest and road construction and reconstruction with a number of exceptions. Colorado and Idaho each have their own state-specific roadless rules that were developed after state petitions, and those areas aren't subject to the current rescission effort. Nationally, the roadless rule protects about 58 million acres, which is about 1/3 of the national forest system, with about 45 million acres covered by this current rescission effort. These places are hugely important for outdoor recreation. Looking at just those 45 million acres that are subject to the rescission, there are nearly 9,000 climbing routes and boulder problems, nearly 800 miles of whitewater paddling and huge areas of headwaters, 25,000 plus miles of trails, including almost 11,000 miles that are open to biking. And, just from a quality and access standpoint, it's important to recognize that like for sports like mountain biking that are not permissible in the wilderness, like these are truly like the most exceptional places you can go to, pursue your sport. In August, the Forest Service published an NOI announcing its intent to repeal the roadless rule, again, excluding Colorado and Idaho with a 21-day comment period. And we're expecting to see a DEIS at the beginning of next year. Why are they doing this? The NOI focused on a few things. It leaned pretty heavily into this idea that there's no need for a one-size-fits-all national rule, and they're expressed an interest to kind of devolve these decisions to the local level. It talked about the president's deregulatory agenda and executive orders on timber production and energy. And it talked a bit about wildfire risk, which I think is maybe worth honing in on for a moment. More than 75% of human-caused wildfires start within half a mile of roads, and 85% of wildfires are started by humans. I think it's potentially there's a reasonable conversation to be had around wildfire risk, especially in the wildland-urban interface or the WUI. But the NOI really overstates what that intersection looks like. They use a definition of the WUI coming from the Healthy Forest Restoration Act to come up with a number around 10 million acres of that intersection between the WUI and roadless areas. But if you use the Forest Service's like sort of peer-reviewed science and their actual WUI geospatial data layer, that number is more like 1 million acres. And so, there might be a conversation to be had there. Lastly, I guess, fuel treatments are happening all the time right now in roadless areas. Nationally, about 2 million acres have been treated in roadless areas, and about 14% of all the fuel treatments that have happened in the West have been in roadless areas. Why is this really happening? I think that there's a fixation in the administration on timber production. And I think part of that is an acknowledgement of the housing affordability crisis in this country, and also probably the recognition that a number of their other policies are pushing in the other direction on housing affordability, particularly immigration, tariff policy. And so I think there's an idea that they're going to make up for this in some way by facilitating a bunch of logging in roadless areas. And then the other piece is something that we've heard from folks within the Forest Service, which is, and I think really across the government, which is that there is a push to get rid of essentially any regulation that's not statutorily obligatory. If there is a line in the CFR that Congress did not require them to put there, they would like to rescind that. I wish I had something profound to say about what this portends for multiple use management or the future of public lands, but I think that generally it's just a statement of where the administration's priorities are around public lands management issues. Conservation is not a priority, recreation is not a priority. The priority is extractive development. I guess I will say from an outdoor recreation standpoint, it's really important that there's a real spectrum of protected designations on public lands, and that we're not just in this sort of binary regime where there's completely unprotected multiple use land on one hand and wilderness and national parks on the other hand. We really need that whole spectrum, from like city parks to front country areas where there are stacked use or stacked loop trail systems and activity specific trails, like for uses like mountain biking, to places like roadless areas where there's a lot of room for active management, but also some focus on conservation, to places where you really just leave it alone. And to see that kind of middle ground protective regime being dismantled is pretty disheartening. I think, the public lands rule is not exactly a protected designation, but I think it fits in the same idea around how do we provide for a greater level of conservation in areas that are managed for multiple use. And that's plainly something that's under attack right now.
Thanks. All right. So now we are going to turn to another hot topic of the day. It's a little wonky, but could have very major implications on multiple use management going forward. And that is use of the Congressional Review Act to disapprove land management plans. And so we've heard through the last few segments, plans are more important than ever. I see the audience questions about, but isn't it also true that plans never get updated? No one's focusing on planning. We have a lot of outdated plans, that is true. And now, of course, we're rescinding some of the kind of foundational policy regulations that were meant to help, in part, direct planning and all the actions underneath. So anyways, to set a little context for those of you who haven't been following this very wonky issue playing out in Congress over the last few months, the Congressional Review Act, or CRA, was a 1996 law that gives Congress a filibuster-proof tool to disapprove federal agency rules within a limited timeframe of promulgation. It's been rarely used. It's really just a big deal when you are coming up against an election and a potential shift in Congress and the White House. But under the CRA, regardless, agencies must follow specific procedures before a final rule can take effect. And that includes, among other things, sending the rule and supporting documents to Congress. So if Congress then disapproves a rule, the agency is then prohibited from issuing a new rule in substantially the same form. So Congress has used the CRA about 20 times now over its history, but it has never, until a few weeks ago, applied the CRA to review and disapprove federal land or resource management plan. Federal land management agencies' longstanding position has been that such plans are not rules under the CRA and therefore have not submitted them to Congress. Nevertheless, Congress recently disapproved 3 BLM resource management plans that were finalized toward the end of the Biden administration. The first one is the Miles City Plan Amendment in Montana. It's up in the Powder River Basin. I have a picture there. The second one was the RMP for North Dakota, covering a lot of lands with some oil and gas potential. And then the third, also pictured here, is the Central Yukon Resource Management Plan, covering a huge swath of interior Alaska. And that plan, incidentally, did include I think close to 4 million acres of areas of critical environmental concern, which Natalie mentioned, many of which were both nominated and ultimately had co-stewardship arrangements in place with tribes there. So this is the first time, right, irrespective of agencies saying, no, these aren't rules, they're not subject to the CRA. This is the first time that Congress has interpreted the CRA to apply to plans. And we do have additional resolutions of disapproval for other land management plans and other types of programmatic plans that have also been introduced and are pending. So we're going to try to start to tease this out. It's super complicated and frankly chaotic right now. I think no one really knows what's about to happen or what did just happen. So Mark, can you start by explaining a little bit about how planning works and why Congress under FLTMA and NIFMA set out these sort of specific and locally driven procedures and how that fits into multiple use?
Sure. Alison has asked me to tell you everything you need to know about public land use planning in 2 minutes. So bear with me if I exceed that slightly. Hopefully I won't. But let me start just by commenting on the CRA. And the thing that you need to know about the CRA, if you don't already, is that once Congress disapproves a rule or a plan in this case, that agency cannot adopt any substantially similar rule or plan. This is going to have devastating consequences for agencies that are subject to these CRAs, because what are they supposed to do? If they adopt a plan that has similar restrictions in the same area, is that substantially similar? These are things that we really need to be thinking about, and we don't have time really to get into it in detail here. But let me turn to the question of how does land use planning work on public lands? And I guess I'll start by saying that in my judgment, the public land use planning process is badly broken. I wrote an article about this called Rethinking Public Land Use Planning a few years ago, where I've tried to tease this out. I'm happy to share it with anybody if you're interested in learning more about this. But the problem from my perspective is that it takes too long, costs too much, uses way too many agency resources. And the reason that's problematic is that land use plans are the classic kind of decision that can be adapted as we learn more information about the area. And if it takes you 8 to 10 years to do a plan, it's just not practical to think that you're going to adapt that plan to the new information you get. So how should this be done? Let me just try to lay this out really quickly in kind of outline form. So we start land use planning, as you may know, with an inventory of the resources that are there. We then kind of do a zoning kind of exercise where we decide what kinds of uses we want to allow or not allow in particular parts of the planning area. Hopefully we're setting very specific goals and objectives for how we're going to analyze and manage those particular lands. And then critically, we need to set metrics. There's this acronym which I often use in my classes that some of you may be familiar with called SMART. You need standards that are specific, measurable, achievable, realistic, and time-bound. And it's really important if you're thinking about these metrics that they can actually be measured by the agency that is then charged with reviewing whether the plan is going on. So you need really good monitoring to see whether or not those metrics are being achieved. And then, of course, if they're not being achieved, that's when you adapt. And so hopefully we can figure out a way to do these land use plans in just a couple of years. I mean, it's a lot of work to do a plan. These are big areas, but from my perspective, land use planning should never be viewed as done, because if you're adapting to the new information that you're collecting through your monitoring program and you're not achieving your objectives, which is, I think, often going to be the case, then you're adapting. And so you're constantly improving the plan to meet the objectives and goals that you've set for that plan. So that's a real superficial kind of look at how I see land use planning should work. And trust me, it doesn't work that way today, but we can talk about that maybe in the Q&A. Thanks.
Okay, Natalie, can you maybe put back on your hat of having advised on this type of stuff in your last stint at Interior, and maybe help the audience understand why this is such a big deal?
Yeah, well, I think, first of all, I think land use planning, it takes too long, costs too much money. But the reason that it functions that way, not that there isn't room for improvement, there certainly is it's considered inherently democratic, that everybody and their brother and sister and whole family get a seat at the table. There are tons of public comment periods, public review periods, there's objection periods. There are lots of places where the community has a lot of input into what's going to happen in their backyard. And so a lot of times when changes are made, the idea is, well, we need to tell the public about that. I mean, I know that's a quaint concept now, but they ask before they make a change where you live. And so it can result in, when there are climate changes or natural disasters or anything, you have to do planning amendments. And so you feel like you're in this cycle of endless planning. And because they take so long and are so hard to do, I think that's why they were never submitted. They weren't understood to be rules, and it didn't make a lot of sense that you would have one Congress, the non-experts, out of all the thousands of people that have just participated in a plan, including members of the public, that Congress would come in and say, we don't like this, we're going to pull that. So since 1995, which was the operational date of the CRA, plans have not been submitted to Congress. If this is their interpretation that now they should have been submitted, there are no valid management plans in the United States. And what about all of the grazing leases, oil and gas leasing permits, everything issued under those plans? So I think it's a mistake in terms of, one, understanding of the law. I can't imagine that something this public, that didn't really just come from the agency, but that is meant to be a process on purpose to put everybody at the table, could be undone by one or two legislators who've decided they hate it for one reason or another. But within the agency, I cannot see, now being familiar with the process and why it takes so long, I cannot see how you will have valid land management planning if they allow them to change them with the political winds, because you'll always be planning and never have a final plan. And for the ones that are there now, you know, the question is what happens to them, and if they're not considered valid, what do you go back to? Something from the 80s, you know, where the ecosystem was different, the climate was different in a lot of these areas. So it doesn't make a lot of sense from the agency's ability to manage land. You will just end up in a constant cycle of planning where you have to add even more seats to the table to make sure everybody is happy so they don't just revoke it when Congress flips. And that, I think, will make it even worse. And so that's how I look at some of the recent actions.
So Katie, what is your perspective on all of that as you advise your clients?
One thing that I think would be interesting that just occurred to me when Natalie was speaking is to do a little bit of a case study to figure out sort of the political dynamics behind the few resource management plans that were selected for the CRA. Because I know there were some quite controversial land use plans that did not get subject to the CRA, and that really surprises me. So I'd be curious to know about kind of behind the scenes why, and I assume it comes from the legislators from that state, for example, in North Dakota and Montana, perhaps, but there were some controversial plans that were wound up in Wyoming that were finalized at the end of the Biden administration in Wyoming. And why didn't those plans also get subject to the CRA? Why was there a sentiment that it was better to go back through, my understanding is go back through the long, tedious, and expensive planning process rather than just having Congress come in and do away with it with a pen? So I think it would, in some ways, like a little bit of a post-mortem analysis of how did we get to the CRA with those land use plans would be interesting for all the academics in the room. Please just drop a footnote when you write that article with some credit. Thank you. No, but I think what's interesting from the the private side is this concept that now we don't have any valid land management plans, and there's been all these authorizations on the public lands that don't have a valid land use plan behind them, right? Because every permit or lease, any action that the BLM takes needs to be in conformance or consistent with an existing plan. And so, what does this do to the state of the world? And I've been giving this a little bit of thought because I think kind of there's this, it sounds scary, and then you break it down and it still would be a mess. Don't get me wrong. It's just a magnitude of the mess. And I think, initially it was, well, you would go back to the pre-1996 resource management plans that were in effect. And most places, I think, by 1996 did have some sort of a resource management plan. I think there was a few, maybe in Utah, that might have even still had those old MFPs. I forget what they were called, but those older plans, I guess conceivably. But most places had a valid plan. And then so then what does that mean for all the permits? Well, those permits are not, and I don't think could just be invalidated. Who would invalidate them? That would be the question. Citizens could challenge them, I suppose, but you would need to establish that your challenge is not moot, that the permit or whatever still, is in existence. Any statute of limitations on the permit issuance hasn't run, and that the plaintiff actually has, the citizen has standing to challenge it. So you'd have to overcome those hurdles. And then you also have this question about, okay, well, going back to these pre-1996 RMPs, is the permit or whatever, I'm calling it a permit, but any kind of authorization, is it consistent with that RMP? And if it's, and probably yes, because those RMPs were, I would say that over time, the trajectory of RMPs has been to become more prescriptive, right? And so most likely that underlying RMP is still, the permit is still valid is still in conformance and consistent with that underlying RMP. And then you get into much, I think, hairier issues that I don't have time to go into. But I just, I don't know if it would cause complete chaos, but it would be certainly for any actions within the APA's 6-year standard statute of limitations. Any permit in the last 6 years, that would be, those would be hairier.
Thanks. I'm going to speak to one of the questions that came in about this. So, and this gets a little to your point, Katie, about the sort of how did they choose these three? So someone asked, why, wait a minute, I thought that 60-day window when Congress gets to review things under the CRA long passed. How did they do this? And the answer is that a member of Congress from North Dakota, another one from Alaska, another one from Montana, submitted a request to the Government Accountability Office and asked them for an opinion. Is the Miles City Resource Management Plan Amendment a rule under the CRA? And the GAO, in non-binding opinions, said, yes, we think it is. And this isn't new for the GAO. This has been percolating since the late 90s. And there's been smatterings of GAO opinions coming to that conclusion for some time, but this is the first time Congress has acted on those. So Congress created a workaround. It's not in the CRA, right? Because remember, the agencies didn't submit these, so there was nothing to start that 60-day clock. And they decided instead to work off of those non-binding GAO opinions, read them into the congressional record, and just sort of manufacture a process where they say that's what starts the 60-day clock. So that's what's happened with these three. I will say there are more pending, including at least one of the Buffalo, Wyoming Resource Management Plan Amendment. And, you know, I think it would not surprise me now that this is happening if we see more move forward. So I predict we're not done yet, but we'll see. So Louis, we've talked a little bit about what the longer term implications of this might be on planning and why that matters. I mean, I guess I will say I'm not sure I agree with Natalie that this is gonna create an endless cycle of planning. I actually think it might completely stagnate planning and disincentivize planning. So that we just, you know, we're doing all of our oil and gas leasing and mitigation measures under the One Big Beautiful Bill Act under, you know, 40-year-old direction. Because what land manager in their right mind wants to take this on, given how chaotic and politicized it is? So I don't know, what are your thoughts on how this all fits with planning?
I mean, so I guess I'm going to speak a little bit more from the perspective of forest planning, just because that's where my experience is. But I mean, certainly planning is super important for outdoor recreation, partially because it's really the headwaters for protective designations. And there are these requirements that the agencies go out and inventory for eligible wild and scenic rivers and recommended wilderness. And you know, just thinking about the conversation we've been having, like, I don't know how you go back and do those inventories in accordance with the requirements of the Wilderness Act, the Wild and Scenic Rivers Act, and don't come back with something that's substantially similar. That kind of like zoning function that Mark was talking about, I mean, again, just like super important for outdoor recreation, things like timber suitability, the application of the recreation opportunity spectrum on national forests, which also, you know, sets the table for travel management, which is, again, a policy that's under threat from this administration. I guess I would just add that, like, you know, these are, I think, really kind of to Natalie's point, it's like these are really incredibly resource intensive processes, especially for outside folks who want to participate and show up for their communities in various ways, you know, particularly when there's some more formalized collaborative process. And I think, you know, we have a lot of experience of, like, you know, stakeholders participating in these collaboratives and coming to some really, like, sometimes semi-miraculous level of agreement on what a forest plan can look like. And then, you know, the Forest Service at least is still, like, super responsive to local political pressure and can totally just go in a completely different direction despite that level of stakeholder consensus. And I think adding in a whole nother layer of uncertainty with this CRA threat kind of floating around out there, I think it's just going to make it that much harder for the folks who we really want to be showing up and participating in these planning processes to make that a priority.
Yep. Okay, I know there's a few more questions on CRAs, but so maybe we'll circle back to it if we have time at the end. Thank you all. I guess we'll all stay tuned and see what happens in our brave new world where the CRA applies to land management plans. Okay, so before we turn to Q&A, our sort of last little segment here, let's, and this is going to be a little all over the map because we're going to try to hit on some of the sort of cross-cutting doctrinal changes and kind of how these multiple use policy issues of the day fit in the broader context, and also how we advocate across the three branches of federal government during such a dynamic time. So hoping that each of you can share some insights on the little bullet points I put up here, whichever ones you want to tackle, and then maybe conclude by sharing one thing that the audience might find surprising or that gives you some hope or inspiration for the future of multiple use management. So Mark, why don't you, admin law professor, kick us off.
Hope and inspiration is not where I was thinking of going on this, but let me try at least to talk a little bit about where administrative law is. Yes, so those of us who teach in the administrative law area have a really tough task these days because the law is just changing in fundamental ways that just were never really expected or anticipated. I mean, you're all familiar with the Loper-Bright decision and overturning Chevron, and frankly, I think that is the least of the problems that we have. I'd like to remind my students that Chevron was a case where the environment basically lost, right? The court basically held that the EPA could allow dirty air areas to get dirtier as a result of that particular decision. And I think it was always a mixed bag. And in any event, we talk about agency deference, but in many cases, led by Justice Scalia, the court was able to determine that there was no ambiguity in the particular law or provision. And so if there's no ambiguity, remember, you stop at step one of the Chevron approach and you just interpret the law as it's written. And of course, Scalia was incredible at finding clarity in language that I think many people had a hard time understanding. So Chevron, I think, is the least of our worries. And frankly, I think that there is some advantage to the Skidmore standard, depending on how it plays out in the courts. That's sort of the substitute standard that's there. Now, I don't have the same warm and fuzzy feeling about the major questions doctrine and the West Virginia versus EPA case, which I think is a disaster. The court basically says in West Virginia versus EPA that agencies have no authority to adopt rules in a particular area without a specific delegation of that power, very specific delegation, if it involves a major question. And the court decides what a major question is. And while it seems on its face that the court is suggesting they're deferring to the Congress, we all know that Congress is not capable of delegating in very specific ways. And so the end result is that the court has essentially arrogated that power to itself by basically denying government agencies the ability to regulate in the most important areas involving major questions. And so it is, in many ways, I think, a really outrageous extension of the court's power and problematic. I'll just mention one other case, and I want to make one other point. There are a lot of cases here that we could be talking about, but I think one interesting case worth mentioning is the Corner Post case. So this was the case that involved the regulations that were affecting a guy in North Dakota. And those regulations had long since passed the 6-year statute of limitations deadline for filing a lawsuit. And the court nonetheless said that that statute did not start to run until the person was affected by the rule. And, this, of course, is extremely disruptive of government agency regulation because it means that you can never be certain about the finality of your rules. And so it is highly problematic from the agency's perspective. Having said that, I'm somewhat sympathetic to the result in the sense that, what is the person supposed to do? If they were first just affected by the rule and now they think that the rule is invalid, should there be some way for them to contest that? I mean, I've been thinking about ways, for example, to maybe improve the way that we do petitions for rulemaking, maybe as kind of an end around so that we don't have to go the way Corner Post goes toward essentially upending old, longstanding rules. But it's a very difficult issue, I think. One other issue I just want to mention, I briefly touched on this at the beginning, which is the problems that we have today with notice and comment rulemaking. And I mentioned, I think, something earlier about the fact that the government isn't giving us the chance to comment in many of these cases. This is a really serious problem. I don't know how many of you are familiar with sort of the notice and comment process under the APA and the provision that allows you to avoid notice and comment if you can show good cause for avoiding notice and comment. But the Trump administration is blowing a massive hole in the good cause exemption to rulemaking. They are applying it in all kinds of cases where it was never intended to be applied. And it's a very difficult issue in many ways. They used the good cause exemption, for example, to repeal the NEPA rules and a number of other really important rules. They're just blowing through notice and comment. And just one last thought about that, something I alluded to earlier. If you're not giving the public an opportunity to comment, and by the way, with what we would call interim final rules, you usually get an opportunity to comment after the rule becomes effective, which means that there virtually is never any reasonable response to those comments because they presumably have to publish a final rule, but they often wait years before they publish a final rule, because why should they? The rule's in effect, they get to use it. But that lack of comment and the lack of response from an agency is significantly problematic in terms of the administrative record. Because when you sue an agency in court to challenge a rule, you rely on the administrative record, which includes public comments and the response to public comments from agencies. Do you really have to wait for 3, 4, 5 years before the agency finally decides to respond to those comments before you can challenge a rule that you believe was promulgated illegally? I'm hoping we're going to see some litigation on this. Some of the environmental groups have sued over the Quad O rules, the oil and gas rules that were recently promulgated and repealed. Or actually what the Trump administration did was delay the implementation of those rules, but I think it's a precursor to maybe repealing the rules entirely. Really interesting to watch that. There are some really significant climate impacts from even delaying that particular rule. And so these are things that I think we all need to be watching. I went over my 2 minutes.
No, you're good. So Natalie, I'm going to ask you, is NEPA dead? And just to toss in a few audience questions here, I am seeing real concern from folks about this. What can the public do if you can't comment on a timber sale? Are we actually going to get a chance to comment on the draft EIS for the roadless rule rescission? The Forest Service says so, but we also now have mine authorizations where there was no draft EIS, right? And they just relied on a scoping period. So tell us what you think about NEPA these days, Natalie.
I have many thoughts. I'm going to combine them into a nice packed 2 minutes. So I think, and we talked about, in planning the sort of inherently democratic process where everybody gets to participate, and that's why it takes so long and becomes unwieldy. Well, that's also why NEPA takes 6 to 12 months for an EA or 2 years for an EIS, is because it also involves a lot of scientific study to make sure you understand your impacts on the landscape, a lot of opportunities for public comment. And the changes that happened this year were just seismic in terms of NEPA, but it's not dead because it's still a statute. They just revoked the regulations. The challenge is that a lot of the case law was interpreting the regulations and not the statute. So people now have to, good luck, you get to build all the new case law around the exact language of the statute instead. The new regulations, which had existed for 50 years, CEQ's regulations on implementation of NEPA, were what all the agencies look to for a uniform standard. And they are now limited to emergency situations in DOI and the use of categorical exclusions, which is exactly like it sounds for those of you that haven't been in agencies, where you exempt whole categories of activities, like shifting a lease from one owner to another, and also to applicant-prepared EISs and EAs, which means the project proponent says, oh, we'll do your NEPA for you. That, that kind of approach would still be covered. So that's it. And all other direction regarding NEPA was shifted to guidance documents and policy documents. And so, in terms of interiors guidance and policy documents, at least there is now for EAs, which are the environmental assessments, the smaller NEPA for actions that are considered to have less impact, no requirement for public participation of any kind other than just posting it on the website, but there's no comment period or place for you to send it now for EAs, which is absolutely shocking and not something any administration has considered in recent memory, because again, it's supposed to be that you want the people to have ability to comment about the places where they live, work, and recreate. For EISs, there's a requirement to publish a notice of intent, to seek input, and to conduct a scoping process. There is a requirement for EISs to request comments. The time period is not specified. It's really kind of vague as to when. During the preparation, as long as that time period is quote unquote reasonable. I don't know what that means. I guess we'll find out. And quote, seek to provide 30 days to the extent practicable, which of course is meant to create a big hole of, we have an energy emergency, we have something, so it's not practicable for us to provide you 30 days public for comments to be submitted. So nothing under EA. So the main change in NEPA is that The statute is not dead. The regulations being revoked means that all the public process aspects have radically changed. Agencies are only required to seek comment now from other federal, state, local, and tribal agencies and an applicant. So this is one way where if you're working in an area, working with a tribal partner, they will have a right to submit comments in a lot of these areas. But it says that agencies may request comments from the public. So I'm going to express a moment of optimism that many people working, for example, in Interior have been there a very, very long time. And they're obviously sticking it out through some pretty difficult time periods. I'm going to hope that that discretionary option, that they will still retain comment periods. That's my hope, at least, because it leaves a space for them to do that. The key here is going to be proactive and try and seek out these opportunities. They're going to be short if and when they are provided. And it's a real challenge, especially if they foreclose comment periods altogether, to figure out how to get a lot of that submitted. I would point out that under the Federal Land Policy Management Act, FLPMA, that the public is still required to be involved. So what you want to do is look instead from NEPA, where they've gutted a lot of public participation requirements, is to look to the public participation requirements in FLPMA and use those windows to participate, I think. And in terms of one optimistic thing or note for the future, right, which is that every administration is temporary, although they can do lasting damage, of course, as we know from many aspects of things we're dealing with now, is that for some folks in our communities, I'm talking specifically about the folks we work with, tribes and others, the previous system wasn't so great. It didn't necessarily work perfectly for them anyway. You could have an acre of land within the exterior boundaries of a reservation that federal government wasn't using. It's still really hard to transfer it back because the system is very detailed and very process oriented in a way that's meant to be fair, but has become burdensome in a lot of ways. So the system, I think, is very challenging. And what happens when something is broken is the people who are still there at the end get the opportunity to build it the way that it should be. So one thing that I would tell people in terms of, some optimistic look to the future is to all of us work in some of these spaces, whether you're a law student and going to be clerking or wherever else going to be interning, or whether you're working in these areas, is to think about ways in which things need to be rebuilt in a different way that serves the public differently, because it was very hard to change a lot of these processes, darn near impossible when you're inside. But now that many of them are broken or gone in the case of EAs, what should it look like when the next administration says, we're putting public comment back in? How do you make it better? So
thanks. So Katie, how are you thinking about NEPA on behalf of often project applicants and rights holders? And then how are you also thinking about agency deference? Mark talked a little bit about Loper Bright and that world.
Well, I think as a practical matter, we still have to see how NEPA shakes out, right? I think that in some ways, there's not one. I think when you look at NEPA, you have to look at it beginning in 2023 with the statutory changes to the Fiscal Responsibility Act. In the statutory changes were in the Fiscal Responsibility Act. They amended NEPA. They Congress instituted some deadlines, for example, that are advantageous to project proponents. And then you have the Marin County decision, which held that the CEQ did not have the authority to issue regulations that bind other federal agencies, which became the underpinning for the revocation of the CEQ or the rescission of the CEQ regs. And then you also have the 7-county decision. So it's not one thing. It's not necessarily this current administration. So I think NEPA is just right now in a big state of flux. And I'll be curious to see how it emerges on the other side, frankly. In part because right now, a lot of the for example, Interior's NEPA implementation rules are all in non-binding or just guidance documents that can be undone with the stroke of a pen. So right now they're not particularly durable. I don't know if there will be a rulemaking later on. I don't know if they're intended to be something that can be changed easily. I don't have any insight. You guys know as much as I do. So, but I do think we're in just a big state of flux in NEPA at the moment. That is, I guess, fun to be a practitioner in NEPA. It's also overwhelming at times, just because we don't really know what things look like. The other thing, though, it kind of dovetails into the question of agency deference, because we hear a lot that after Loper Bright, that deference is dead. Deference, we don't have deference. Agencies don't have deference. And so two things. One is I always laugh because deference, I think, is the great unifier, right? Like, do you like an agency decision? Yes, then you like deference. Do you like the agency decision? No, then you really don't like deference. And there's a lot of people, probably, I'm guessing, in the next 4 years, they're gonna be relying on Loper Bright to try and quite frankly undo what this administration is doing. So to me, deference is always, whether you like it or not, is always what angle you're looking at. But with respect to NEPA, in particular in agency deference, we saw in the 7-county decision out of the Supreme Court last term that the Supreme Court said, well, no, when it comes to NEPA, we are going to afford agencies substantial deference. And that's the words that the Supreme Court used. So like in certain contexts, not in the, we're interpreting a statute and a formal regulation, that unique or the discrete circumstances that were addressed in Loper Bright, we see the Supreme Court saying, no, we need to let agencies do their business. And I mean, you think bringing it back to public lands, that's a theme we heard in the Sua v. Norton decision 20 years ago, right? Like, give the agency the latitude to manage its own priorities, the impossible, the impossibly complicated task of managing its priorities. I think you can see themes of that in 7-county.
Thanks. Louis, can you talk a little bit, especially for the students, I think, about like what on earth does it look like to try to influence all of these issues right now in Congress? I know you do a lot of that.
Yeah, it's hard to like say something super optimistic about lobbying in Congress right now, but I will try. Things are not great. I think one of the most challenging things has just sort of been seeing the degree to which Congress has been pretty reticent about asserting its own prerogatives on a whole range of things, but particularly around how the appropriations process plays out and how money gets spent or not spent. I was just in DC earlier this week. I would not say that the vibes are spectacular. But, I feel like we had this like really tremendous moment earlier in the spring or early summer around the inclusion of public land sell-offs in the reconciliation package, and just the outpouring of enthusiasm for public lands from people all across the political spectrum, from outdoor recreation folks to hunters and anglers to the motorized rec community to conservationists. That was a big deal. And that outpouring of public affection for public lands, coupled with, I think, a lot of long-term work by people in their communities to build relationships with their representatives in Congress, that all kind of like culminated in, a half a dozen members of Congress writing a letter to Speaker Johnson and saying, we will not vote for any reconciliation package that includes land sales. And it's easy to be sort of like the glass half empty about that, and to feel like it took this monumental effort to get Congress to clear kind of the lowest possible bar. But, at the same time, like the amount of political pressure that those members were under to, pass this thing was pretty astronomical. And, I feel like we really have something as kind of a public lands community to build on there. Like, how do we really support those members who stuck their neck out on protecting public lands? How do we build on that kind of core group? How do we encourage those folks to go a little further in what they're ready to use their leverage on, in protecting a lot of the things that we've been talking about on the panel already? There's really something to build on there, and that's certainly been like our organizational focus. And I'm pretty optimistic, honestly, about the prospects of doing that. Excellent.
All right, Chris gave me permission to go a few minutes over so we can take a couple more audience questions. So yesterday, in that fascinating debate between Ethan Blevins and Professor Leshy, we heard a perspective around the constitutionality of FLTMA. We also have seen arguments related to that sort of percolate, actually in some of the litigation originally challenging the public lands rule, which now, of course, has long been stayed as the rescission proceeds. And I see glimmers of some of those rationales actually make their way into BLM's rationale for rescinding the public lands rule. So the question is, what do we think about FLPMA and multiple use management? Might it have a similar fate of NEPA where, it's some shadow of itself and we don't really know? Is that where we're headed? What do y'all think?
I'll play optimist and say it's not heading the same way. I would point out, by the way, the Marin County decision went up to the Court of Appeals en banc, and it's a curious kind of decision, but a majority of the court, a slim majority of the court, basically said that decision to basically say the CEQ had no authority to issue those rules did not need to be decided. It was basically it was dictum, essentially, is what the court said. And so I don't think we can say that the law right now is that the CEQ lacks authority to issue rules. Obviously, there was a repeal of the original Carter executive order on that, but I think it remains to be seen whether CEQ might come back to life, might like a phoenix rise again. We'll see. But in terms of FLPMA, I just think, I'm a big fan of John's arguments here on the property clause, and I think that there's a lot of merit to the idea that Congress has this plenary authority. The court has said it time and again. I think it's pretty well established, and that's all that's going on with FLPMA. Congress is basically directing how our public land should be managed. That's what the property clause, I think, intended for Congress to do. So I'm not, famous last words, I'm not too worried about FLPMA being sort of cut down in the way that NEPA was, but I guess we'll see.
Yeah, I tend to agree with that, because you don't see, let's kind of setting Marin County aside, there's that quote from Stedman County where the legislative acorn has grown into the judicial oak, right? Like you had the CQ regs, you had that big treatise, the Mandelker treatise, if anybody reads that, it's like, you had this weight of, first off, authority, but then you also had this, I think from a project, for some areas, you had this, depending on what the nature of the use was for NEPA or the approval, you had the sense that you were always running in quicksand, right? Like you could never get anything done. The process was cumbersome. FLPMA does not suffer from those same characteristics. It's planning, time consuming and expensive, yes. Might there be ways out there to somehow make planning more efficient? Yes. But I think it would be pretty radical to just take FLPMA off the table, or to just kind of see the completely wholesale changes we're seeing in NEPA, because you didn't see those two significant characteristics in FLPMA that you saw with NEPA.
Excellent. Well, I think we've covered most of the topics that kind of made their way into the questions from what I'm seeing on Slido. So we'll wrap up. Thanks, everyone.